All right, I'm going to go ahead and read some names through the docket. And if you're here, just let me know you're here. I know we have another docket that started before this one across the street. And so that's where many of the attorneys are, if y'all are wondering. So they should be here shortly.
Where are they, Justin? Sorry.
Perryman's got her arraignment docket, and she starts at 8:30 to obvious reasons. Guess we could start at 8. Yeah, me either. All right, Felton Brewer. They're a Felton Brewer. All right, this is cause number CR 20-0710-173, the state of Texas versus Felton Brewer. Is there a Felton Brewer in the courtroom? See no one, I hear no answer. He's not in the lobby. Time is now 9:17. The docket was set for 9 a.m. The court will entertain a motion. Granted capious issue, he'll be held with no bond. Mr. Head, you ready on anything?
Yes, sir, Your Honor. Page 5. Russell.
D'Angelo Ramon Russell. Come on up, sir. This is cause number CR 21-0178-173, the state of Texas versus D'Angelo Russell, set for, I've got it listed for discovery status and pretrial.
I just showed pretrial, Judge.
Okay, either way, any pretrial from the state.
Just for a standard motion for discovery, Judge.
No objection.
Granted, and on behalf of Mr. Russell.
Your Honor, we don't have any contested pretrial motions filed.
All righty, may I see the docket sheet? All right, when the court deems pretrial is held, Mr. Russell, your next court date is August the 12th at 1:30 for status, which is typically your last day to resolve your case before it ends up on the trial docket. I'm also going to order you to take a drug test today. You know the drill. You'll go with probation, take the test. When you get done, come on back in the courtroom and we'll go over the results together.
And on page 4, James Cheek.
James Cheek. All right, cause number CR 21-0197-173, the state of Texas versus James Cheek. Is there a James Cheek in the courtroom? I hear no answer. He's not in the lobby. Mr. Head.
Your Honor, I will try to call him. I believe I've got a good phone number and he's appeared before, so I'll step out over the break.
Well, I'm going to go ahead and call it, and that way if he shows up, I'm here all day.
Yes, sir.
He's not in the lobby. The court will entertain a motion. Granted capious issue, he'll be held with no bond. Again, I'm here all day if we find him.
Yes, sir, Your Honor. And if I could just visit with my other 2 clients before announcing on those.
Sure.
Thank you, Your Honor.
All right, again, we'll get back through the docket. If you hear your name called, just let me know that you're here. Logan Grimes. He's in Navarro County.
Your Honor, that's my client, and I understand he's in
it.
Navarro County.
No, you don't have to call him, Ronnie. He's in Navarro County. If we can reset Logan Grimes for August 11th at 1:30, and if y'all get me a bench warrant, I'll sign it.
Your Honor, yes, Your Honor. Logan Grimes is also set this afternoon at 1:30.
Hold on, Miss Altier. I don't have my TVs turned on. I know you can hear me, but my sound goes to the television. There you are. Can you hear me?
Yes, I can.
All right, so we called Mr. Brewer's name and he is not present. And Mr. Grimes is in the Nevada County Jail. And so we reset Grimes to August 11th at 1:30 and are going to get a bench warrant to get him here.
Okay, he's also on your afternoon docket. On the court docket, it shows him for 9 o'clock and for 1:30, Logan Grimes.
We fixed it. And so he's not, either
Okay.
way, he's in Nevada County.
Okay, and Felton Brewer, I told him to be there, but I'm going to be physically there this afternoon, and I'll get Felton Brewer there this afternoon too, if that's okay with the court.
I'll hear his excuse.
Okay. All right, that's all I have for this morning.
Yep.
May I sign off and see you this afternoon?
Yes, ma'am. Thank you.
All right, thank you.
All right, so Jason Bowers, gotcha. Michael Graham, gotcha. Misty Green. She's here, okay. Esmeralda Ibarra, gotcha. Jamie Nelson, see you over there. Joshua Redwine, got you. Christopher Smith. All right, I think your attorney's out in the hallway. Sabian Young, got you. I think Mr. Cook is with Mr. Head. All right. Kimberly Harris. Kimberly Harris. Cause number CR 21-0087-173, the state of Texas versus Kimberly Harris. Is there a Kimberly Harris in the courtroom? See no one, I hear no answer.
No answer, Your Honor.
All right. Time is now 9:23. She was set for docket at 9 a.m. The court will entertain a motion. Granted, capious issue shall be held with no bond. Misty Warren.
This is Warren.
Okay. Michael Mitchell. Gotcha. That's it. Anything else ready? Going once? I don't even see any defense attorneys. Going twice? All right, I'll take a recess, y'all. Let me know.
Yeah. Anything, yeah, just anything. Okay, I just want to make sure I wasn't talking about. That's good. Yeah. Okay. No, but we're gonna give them a ride real quick. We're gonna give them a free ride. For a place to stay, free meal. Yep.
I have certified to the state. We have the Efren Garcia. Yeah, we have to send a certified copy to the state. And the client has to have a certified copy to carry around with them. Thank you. So, I'm not sure, but he's got it. Sure. Sure.
Yes, I knew there was something to talk about. Oh.
Y'all can be seated. Thank you. All right, continuing on with open announcements, Mr. Hunt.
Misty Ward, plea your oath. I do not know which page she's on. Page 6, Your Honor. I believe.
Misty Warren. Most important sheet. Mr. Russell, pass your test, sir. You're free to go. We'll see you at your next setting. All right, this is cause number CR 21-0147-173, the state of Texas versus Misty Dawn Warren, set for pretrial today. However, a plea has been presented to the court. Is the state ready?
We're ready, Judge.
And on behalf of Miss Warren,
Miss Warren's ready, Your Honor.
all right, ma'am, is your name Misty Dawn Warren?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes, sir.
If I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Miss Warren, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Miss Warren, have you ever been treated for any mental health or emotional issues? Do you understand what's going on in here today?
Yes, sir.
You need to speak up just a little bit more
Right,
because we
yes,
have
sir.
trouble hearing you through that mask. All right, and Mr. Hunt, do you believe the client is competent?
I do, Your Honor.
And the court finds she is. Miss Warren, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
Do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand that range of punishment? However, it's my understanding that you have this deal worked out with the state where in exchange for your guilty plea, they would recommend that this be convicted and punished as a class A misdemeanor, carries a punishment range of up to 1 year in the county jail and a fine of up to $4,000. Do you understand both those ranges of punishment?
Yes, sir.
And the plea bargain?
Your Honor, it's 4 days confinement in the Henderson County Jail. 4 days served plus a $200 fine, attorney's fees, court costs, and live restitution.
Is that your understanding of the plea bargain, Ms. Warren?
Yes, sir.
And is that your understanding, Mr. Hunt?
It is, Your Honor.
Well, Ms. Warren, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of Mr. Hunt?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Hunt? And did you sign that second page?
Yes, sir.
Do you have any questions about it?
No,
Do you have any questions about any of the documents that you read and went over with Mr. Hunt?
no, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury.
Yes, sir.
Do you want a jury trial?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain?
Yes, sir.
And I'll ask you, ma'am, how do you plead to that state jail felony? I'm sorry, let's back up. How do you plead to that possession of a controlled substance, punished and convicted under 1244B of our penal code? Are you guilty or not guilty?
Yes, sir.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have states 1 in offense report, states 2 is Michael Ward in compliance, and states 3 is the lab report.
No objection.
Admitted.
State rests.
Defendant rests.
All right, Ms. Warren, then based upon your guilty plea and your evidence, the court has enough evidence to find you guilty and does find you guilty of that possession of a controlled substance under 1244B of our penal code. The court will follow the plea bargain, sentences you to 4 days in the Henderson County Jail with credit for 4 days and orders you to pay your fine, attorney's fees, court costs, and lab fee. And before you go, Ms. Warren, have you had an opportunity to review the judgment of conviction in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, man. Good luck to you. You need to see Mr. Halbert to your right there before you leave.
Thank you.
Thank you, Your Honor. May I be
Yes,
excused?
sir. Appreciate you. Mr. Head.
Your Honor, Kimberly Harris.
Harris, come on up. Harris was late this morning.
She was, Your Honor. She called my office and said she had had to work last night and that she overslept and was on her way. So.
Where's she work at?
I clean offices and homes from.
At least you're working.
I'm sorry.
So I'll recall the bond forfeiture. But again, two things you don't want to be late for, your own wedding and felony court.
I apologize.
Appreciate the fact that you work, though. Not enough people do. All right, this is cause number CR 21-0087-173, the state of Texas versus Kimberly Harris, set for pretrial. I need pretrial from the state.
Is there a standard motion for discovery, Judge?
No objection, Your Honor.
Granted, and Mr. Head?
Your Honor, we do not have any pretrial on file at this time. I would ask the court to allow us to reserve the right to file a motion to suppress if warranted. There's still some discovery that I'm reviewing and I needed to visit with the state about it.
Sure, I'll grant you leave to file anything, just let Kevin know.
And Your Honor, actually, I think we already have it on file. If I could just ask for leave to hear it
Yes,
if
sir.
necessary.
I'll grant you that.
Thank you,
And
Your
can I see the docket sheet? All right, and Ms. Harris, then the court deems pretrial is held. Your next court date is August the 12th at 1:30. However, before you go, I'm ordering you to take a drug test. You know the drill. You'll take the test. When you're done, come back in the courtroom and we'll go over the results. Thank you, ma'am.
Your Honor, Jeremy Cook has a couple of cases starting on page 4.
Mr. Cook, come on up, sir. All right, these are cause numbers CR 19-0748 and 0749-173, and then cause number CR 21-0288 and 0289-173, all styled the state of Texas versus Jeremy Cook and all set for trial docket status.
Judge, Mr. Cook is specially set toward the end of October. I can't recall the exact date off the top of my head. I believe we set this just as kind of a check-in to see where we're at. I believe the court has taken 2 weeks off its calendar for this trial.
Okay,
There's a number of witnesses, but as far as the state's concerned, we're still good to go for October.
And Your Honor, I think it's the 18th. That's my recollection. And we certainly anticipate being ready for trial. It is specially set. If we could, though, there are still some issues that are kind of outstanding. If we could reset it maybe mid-August, just to kind of keep the
Sure.
court apprised of where we are.
what are they discovery issues?
Your Honor, I think there's a report from another law enforcement agency.
Is it a Ranger?
The FBI, I think, had a
Oh, yes.
report that we have not received yet. To my knowledge, we've also requested some information out of Cherokee County, which was an assisting agency over there, and we've had to do some open records requests. We're still waiting on responses to some of that stuff, so we're trying to speed it up as fast as we can. We don't.
Y'all need an
want to
order
postpone
from
it.
me to get anything done?
We might, if that's why I think if we could reset it to August, just to make sure we're getting everything done that needs to be done timely enough to be ready for trial.
The FBI stuff I've got, I can get you that today.
Okay, if you don't mind just shooting us that'd be great.
Okay. All right, well then, we'll go ahead then, Mr. Cook, and we're going to reset this to August 12th. August 12th at 1:30, and we'll just call that a status. And if you got the FBI stuff, that's stuff I thought would be hard. But if the Cherokee County stuff, if y'all need an order from me. I mean, that-
Well, we requested it a long time ago through an open records request. The Attorney General told us we needed to reword our request, so we sent in another request, and I think we're waiting now for a response to that. So, but we certainly should know by mid-August where we
Okay.
stand on that.
Yeah, like I said, if you need an order, just let me know.
Yes, sir. Thank you.
Sir.
Your Honor, I believe that is all I have. That's all.
Yep, that's all I got. John.
Thank you.
Yes,
If I
sir.
can be excused.
Yes, sir. Ms. Fallhaber. Morning.
Got Esmeralda Ibarra on page 2.
Ms. Ibarra. Officer want to search warrant, somebody telling them in court. It's actually Mr. Hutchinson. All right, this is cause number CR 20-0624-173, the state of Texas versus Esmeralda Ibarra. And that is set for pretrial. Any pretrial from the state?
No, Your Honor. We have extended a offer of PTI to Ms. Ibarra. She's done the application and the paperwork. The only thing that's left is she has to pay the $300 PTI fee, which she hasn't done yet. So we're just asking the court, set for pretrial today.
It is.
Okay. We're just asking the court for another date so she can come up with $300, make that payment, and then we'll enter into the PTI agreement.
Can I see the docket sheet?
The last UA was clean, Judge.
Okay. All right, that's fine. I don't need it. All right, well then, August, is that what you want?
It's fine with the state if it's okay with.
August? All right,
Yes, sir.
August 12th at 1:30. And if y'all, well, yeah, because I have to still do the waiver of jury, so we'll do it on that day as long as she's paid up. So, all right, Ms. Ibarra, we will see you August 12th at 1:30.
Thank you.
Yes, ma'am.
Christopher Smith, maybe on call. Maybe you went to the restroom or something. I talked to him with him this
Who,
morning.
which one was it?
Christopher Smith.
Yeah, I think my call too. He was here.
He was here. If we could reserve on him, I can see if I can track him down.
Yeah. You
Thank
got
you.
anything else ready?
Yes, Misty Green,
Mr. Green.
page 2.
All right, this is cause number CR 21-0209-173, the state of Texas versus Misty Green, set for pretrial. Any pretrial from the state?
It's their standard motion for discovery, Judge.
No objection.
Granted, and on behalf of Miss Green,
No pretrial at this point, Your Honor.
does she have an offer?
She does.
All right. Miss Green, you look a little tired. Is something going on with you?
Sir, I've been through a lot in the last couple months. I've just got a lot on my mind.
Okay,
I
I
did just wake up.
Just want to make sure you're in your right mind.
Yes, sir.
All right, well then, ma'am, the court deems pretrial is held. Your next court date is August the 12th at 1:30. I'm also going to order you to take a drug test today based upon your demeanor. You're gonna go take the test. When you get done, come back in the courtroom. We'll go over the results together.
I think you want her to sit in the courtroom until they give her a direction.
Yes, ma'am. Or wherever probation tells you to go.
Jason Bowers on page 2.
Mr. Bowers. All right, this is cause number CR 21-0220-173, the state of Texas versus Jason Bowers, set for pretrial. Any pretrial from the state?
It's our standard motion for discovery, Judge. That's the UA
Gotcha.
order, and that's the order on our motion.
Any objection?
To the standard order, no.
Granted. And on behalf of Mr. Bowers?
No pretrial this time, Your Honor.
All right. Mr. Bowers, and the court deems pretrial is held. Your next court date is August the 12th at 1:30 for status, and that is usually your last day to resolve your case before it ends up on the trial docket. Okay, sir? You gonna fight in the jail? Slipped? Okay, sure you did. All righty. We'll see you in
Hold on,
August.
Let me give you your reset. Stay put.
I have a responsibility with them when they're in court, to make sure they're okay. So,
You did. I think we might be ready on the plea for, oh,
Mr. Head, did you have something while we're waiting on?
Your Honor, if I could just, advise support on Mr. Cheek,
Uh-huh.
James Aaron Cheek. I was able to get in touch with his wife. She said he had to work overnight last night, that she was waking him up. I was gonna ask if I could come
1:30?
to be here at 1:30.
Be here at 1:30. That's fine.
Thank you, Your Honor.
Yes, sir. She not up here yet? Who?
Jamie Nelson.
Oh, I'm sorry. I thought we were waiting for somebody to come in. That's why I was taking Mr. Head. Mr. Nelson, come on up.
We were waiting on the clerk to finish swearing him in, so.
I got
She's
you.
walking back right now.
I knew we were waiting on something. I didn't, wasn't trying to get him to cut in front of you or anything.
Nope, we were good.
Let's go ahead and call them. These are cause numbers CR 17-0907 -392 and cause number CR 20-0267-173. And both of these are styled the state of Texas versus Jamie Nelson, and both set for a plea today. Is the state ready?
We are, Judge.
Is he pleading to both or just one?
Judge, he's pleading on both. CR 17-907 has 2 counts. He's pleading to both counts, and then he's also pleading on CR 2267.
Okay, and so the state's ready.
Yes, sir.
And on behalf of Mr. Nelson,
Ready, Your Honor.
right, sir, is your name Jamie Nelson? You got to speak a little louder. And are you the same person that was originally indicted by Henderson County Grand Jury in this 0907 case?
Yes, sir.
Hold on just a second, let me finish. So he's pleading to both counts or just count one on that?
Both.
Oh, you got one more? All right, let me get both. Let me get them all and then I'll finish. That's what I get for trying to get ahead of myself. Are you all right? All right, then. So, Mr. Nelson, are you the same person in this 0907 case that was indicted by a Henderson County Grand Jury for 2 counts? The first count being evading arrest or detention, and the second count being continuous violence against the family. Are you that same person?
Yes, sir.
And are you also the same person that was indicted by a Henderson County Grand Jury in the 0267 case for that second-degree felony offense of aggravated assault with a deadly weapon?
Yes, sir.
If I can get you to raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
All right, you can lower your hand. Mr. Nelson, can you read and write the English language?
no, sir.
All right, do you understand the English language?
Yes, sir.
All right, and did Ms. Fallhaber explain all these documents that I've got in front of me to you?
Yes, sir.
All right, and are you a U.S. citizen?
Yes.
All right, Mr. Nelson, I'm going to need you to kind of
Yes, sir.
engage with me now and answer my question. All right. Well, if it turns out you're not, and you enter into this plea bargain with the state or these plea bargains, it could result in certain negative immigration consequences. Do you understand that?
Yes, sir.
All right. And Mr. Nelson, I know that you have been treated for some mental health and emotional issues. Is that correct?
Yes, sir.
And we actually sent you, or the court signed an order which sent you for competency restoration. Do you still feel like, since the doctor issued their order, that you still understand what's going on?
Yes, sir.
All right, and Ms. Fallhaber, do you believe your client is competent?
I do, Your Honor.
All right, when the court finds that he is competent based upon his demeanor, the answers to my questions, and the last doctor's report that this court reviewed. Mr. Nelson, I know that we've already arraigned you on all of these cases. However, would you like the prosecutor to read the indictments against you out loud here in the courtroom? Do you understand each of these charges?
Yes, sir.
Well, in this 0907 case, that second degree felony offense, that is a second degree felony. That's what I was looking for. And that carries a punishment range of not less than 2 years nor more than 20 years in the Texas Department of Criminal Justice, and a fine up to $10,000. Do you understand that range of punishment?
Yes, sir.
In this 0907 case, count 1, that evading arrest or detention, that's a third degree felony. The count 2 of that indictment, the continuous violence against the family, that's also a third degree felony. In each of those carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice, and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
And the plea bargains?
Judge, in all three, in CR 2267 and in both counts of CR 17907, 5 years confinement in TBC. In CR 2267, we have 497 days credit. Arrest in court to consider an indicted continuous family violence from November 2018. Also attorney's fees and court costs. CR 17907 1. He has 195 days credit. Plus attorney fees, court costs, and count 2 of 907, he has 555 days credit. Attorney's fees, and all 3 of these sentences are the ones concurrent with each other.
Is that your understanding of the plea bargains, Mr. Nelson?
Yes, sir.
Is that your understanding, Ms. Fallhaber?
It is.
Look at him, he was talking to you. All right, well, Mr. Nelson, a few minutes ago, you told me you could read and write the English language. I'm sorry, you told me that you understood the English language. I apologize. And anyway, I'm going to go over a couple documents with you. The first is the agreed plea recommendation. Right, there's one of these for every case in which you've been charged. Did you have Ms. Fallhaber explain that document, the front side, on each of these cases to you?
Yes, sir.
And did you understand it?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Now, I'm going to show you the back side of just one, but they're all the same. Did she explain to you the back of this and go over it with you? And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir.
Next, I'm going to show you the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, I'm showing you one, but there's one for each count in which you are pleading guilty to today.
Yes, sir.
They're all the same except for the cause number at the top. Did you read and go over, I'm sorry, did Ms. Fallhaber go over these documents with you?
Yes, sir.
And did you sign the back page of each
Yes,
one of
sir.
them? Do you have any questions about it?
No, sir.
Do you have any questions about any of the paperwork that she read and went over with you?
No, sir.
Well, if she read and went over these with you, I know she explained to you that you have many constitutional rights, including the right to trial by jury on all of these cases. Do you understand that?
Yes, sir.
Do you want a jury trial on any of these?
No, sir.
Do you want to waive your right to a jury trial and do these plea bargains?
Yes, sir.
Then I'll ask you, sir, in cause number CR 17-0907-392, as to count 1 of that indictment, that evading arrest or detention, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
In count 2 of that same indictment, that third degree felony offense of continuous violence against the family, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason? In cause number CR 20-0267-173, to that second degree felony offense of aggravated assault with a deadly weapon, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no
Yes,
other
sir.
reason? I'll hear the evidence in all the cases.
Judge, in CR 20, 267, I have stage 1 an offense report, and stage 2 is Michael Morton compliance.
No objection.
Admitted.
For both counts of 017-7, I have stage 1 an offense report, and stage 2 is Michael Morton compliance.
No objection.
Admitted.
State rests in all 3 causes.
Rest as well.
All right, then, Mr. Nelson, based upon, let's back up there. In cause number CR 17-0907-392, as to both counts, based upon your guilty pleas and the evidence, the court has enough evidence to find you guilty and does find you guilty of count 1 and guilty of count 2. The court will follow the plea bargain, sentences you to 5 years on each of those cases, with time credit for 555 days in count 2 and 195 days in count 1. It orders you to pay in each of these cases your attorney's fees, and in count 1, the court costs. In these 2 cases will run concurrent with one another and concurrent with CR 20-0267-173. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense of aggravated assault with a deadly weapon. The court follows the plea bargain, sentences you to 5 years in the Texas Department of Criminal Justice with credit for 497 days as of today. The court is considering the unindicted continuous violence against the family from November of 2018. And this case will run concurrent with both counts in CR 17-0907-392. Now, Mr. Nelson, a couple more things to go over before you go. In each of these cases, there was a judgment of conviction. There's 3 of them here. Did you go over these with Ms. Fallhaver, all 3 of them? Okay, and was your name, the charge, and the time credit correct in each of these? And now, sir, finally, since you've been convicted of these felony offenses, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, you need to consult an attorney, okay? All right, you're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck, Mr. Nelson. You need to see Mr. Halbert to your right. Okay, I got to sign these. We'll have to resolve his cases because he's been hanging around here since 2018.
It's the lowest I've ever seen. 66.
Just catching up on paperwork.
All 73 cases. Last week was his week, this week's my week.
I'm not trying to take care of Dan. Oh,
Go to the dollar store, get you a glass jar. Okay. I'll save my dollar.
all right, who we got next?
Michael Graham, please.
Michael Graham. All right, this is cause number CR 21-0163-173, the state of Texas versus Michael Graham. and set today for pretrial. Any pretrial from the state?
State standard motion for discovery, Judge.
No objection.
All right, granted. And on behalf of Mr. Graham.
Nothing at this point, Your Honor.
All right, well, then the court deems pretrial is held. Mr. Graham, your next court date is on August the 12th at 1:30 for status, and that's typically your last day to resolve your case before it ends up on the trial docket. All right, so once you receive your reset notice, you can have a seat. See you in August. Let's see here. You're it. You got anything else?
I've got a couple bond hearings, but if Mr. Stevens was ready, I have no problem. Okay. Well, then, in that case, Joshua Redwine, Your Honor.
Mr. Redwine, come on up. All right, this is cause number CR 21-0559-392, the state of Texas versus Joshua Redwine. Set today on a motion to reduce bond. Is the defendant ready?
Ready, Your Honor.
And on behalf of the state?
State's ready.
All right, and are we going to hear testimony from your client for the limited purpose of bond?
Yes,
All right, sir, if you can raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. Ms. Cole Haber.
thank you, Your Honor. Mr. Redwine, are you currently being held on a $15,000 bond for the case that's before this court? And
I'm sorry, how much was it? 15 or 50?
15?
15, okay.
And what resources do you have to post that bond?
I guess.
Has your mom been able to afford that bond? Okay. Is it your desire that the judge lower that bond?
Or PR.
Okay, so it's your request that you be given a PR bond on this case? If you were released from custody, where would you stay?
I think at my mom's, maybe a friend of hers that lives a mile from her.
And where is your mom's house?
I'm thinking in either Trinidad or Tool.
So in Henderson County, is that right? Would you appear before the court as directed if you were released?
Yes, sir.
Would you abide by all conditions of bond as set by the court?
Yes, sir.
Is there anything that you'd like the judge to take into consideration when deciding whether or not to give you a PR bond?
So,
I'll pass the witness.
Mr. Cox?
Mr. Redwine, were you working before you got arrested?
sir.
When was the last time you had a job?
Years back,
In years? Okay, so you don't have any savings?
every once in a while, somebody would get picked me up at the store, local convenience store.
Okay. There are no savings or anything like that? What about your mom? Does she work?
She got a check from this guy.
She doesn't have any savings or anything like that? Car, anything, property she could sell to help make a bond?
No.
Anybody else that could help you make a bond? Brothers, sisters, anything like that? Looking at about $1,500 on $15,000 cash surety bond.
My sister, no, but I think my brother-in-law just had a court case, so they spent quite a bit on lawyer.
Okay, your sister work?
I think so.
You know what she does?
It's just home base, I think.
That's the witness.
Nothing further.
Got a probable cause affidavit there? Have you received a copy of this?
I have not.
I'm sorry, I can get you a copy.
Okay,
Why don't you read it before I do? I don't like to read anything before
I appreciate
opposing
that.
counsel does. he? Is he receiving any, any mental health treatment or anything? Is he on any medication or
We've
anything?
discussed that in the past, but if it's okay, I'd rather just ask him again.
Sure.
Are you receiving any mental health treatment?
Not that I know.
Not that you're aware of?
Doctor was. No,
Do you mind have you ever received any mental health treatment?
I've been to Terrell, the state hospital.
So you had an episode here. All right, Mr. Cox, you
I have no position on that, Judge.
any prior criminal history
4 misdemeanor convictions, no felonies.
for?
There was a UCW and a disorderly conduct.
All right, I'm gonna grant the motion to reduce the bond. I'll reduce it to 5,000 surety bond. But I'm gonna make conditions of bond, no firearms. You don't have, he didn't have any guns, does he? And I'm also gonna make a condition of bond that within 72 hours of your release. Have you seen anyone at the Andrews Center before?
Mr. Andrews, Alex, I think.
All right, do you still have that information? Can you still get up there and get your mom to take you up there?
It's Tyler or the Athens.
There's one here in Athens too.
He told me to visit the one in Tyler.
Okay, well then,
They did an IQ test on it. Well, like last time I was in jail.
yeah, well, you need to see them. You need to make arrangements within 72 hours. Call them or something because you probably need to get in there and see what's going on.
And I'll submit an order when I get back to my desk.
Okay. Yes, ma'am.
Okay, thank you. Your Honor, if I could step away, we're still waiting on Ms. Ibarra's test result.
Okay.
Mr. Head's ready.
Mr. Head?
Your Honor, I just had Ms. Harris and it's her understanding she passed the test.
Oh, I'm sorry. I don't have it yet.
I'm sorry, I'm waiting on it. They should be bringing it over shortly.
Wait till I
I
get,
was just waiting to get that. before I left.
okay.
So did you make any Andrew Center or Andrew Center treatment and condition? I didn't catch.
It said that he would make arrangements with the Andersons to be seen. I'm just gonna put it there, what your problem cause that, David.
Thanks.
All right, you're free to go, ma'am. We'll see you in August.
Thank you, sir.
Thank you, guys.
Yes, sir. Anything else ready? So Mr. Stevens is working on all his. Yeah, he's been the last one lately, but he's moving cases. All right, well, y'all let me know when they got something ready. I gotta search for them. I gotta review.
So I'm just looking for this. There's a lot of I was thinking this is the seizures. Had to wait till the case was disposed before you could. I'm just talking my spare time.
Yeah. I got it. It's awesome.
Well, it's just hard because. And so it's like, we might get into great time. Yes. Let's go. See what pages you need. So the TS means time served. Okay. Oh, I just saw the circle there. I just know your staff is so busy, they're trying to do all that research. And all the research on the Jesuit missions. Yeah. So, we must figure it out.
I'm not making her move a lot faster than ours. You didn't know that? You did. Oh, yeah, there is. There has been.
We can close out a lot of our civil cases, and that's what I'm doing. I'm the assistant to the civil coordinator. I can't remember what the official title is, but.
No, she's not a fired from that position.
Wait,
Hey, we're making her a label already, so. You're too late.
She was like a.
no, she's on it. Oh, here.
Pretty smooth. So. Really? So yeah. So. You didn't have anybody on this afternoon that was coming up this afternoon? Or tomorrow?
Yeah.
It's, yeah, you didn't have one. We didn't have one tomorrow. So. There's six grams. Oh, man. That's crazy. 61, 8 to 1 to 41.
Patient zero, zombie apocalypse again.
All went up to jail, man. You've got another one. I was just all over.
Yeah, and I have it, like.
One to play.
Okay, so we're good. Okay, okay, good. Yeah, I just saw that.
She's in it right now, but she didn't. I was hoping. Never got the judge.
I was supposed to posting the people I know.
Just to give you a heads up.
I appreciate it.
But she should be back. Well, I don't believe she was able to get us.
I would imagine doing it on command is a little bit.
It's not very fun. Well, that's what we do. This is number one for the attorneys. Well, I'll give you a page.
A little messy. That's all. We were talking about that. Right. Everyone, you can work something on. The band as a whole, because the bond company in April, the AOS, that they were arrested, and he was in jail a year.
Okay.
And we were under the first move.
Sweet.
On the dope case, it's more than that. So
Okay. I mean, I sent you a really good yet. I've been working on it.
Coming back.
We're ready.
Ready for our bond hearing. I'm still waiting on the screen script test. Yes. You? Not seeing the rest. Prosecutor's game.
Sitting off that metal.
Yeah. Those old bosses, he's out there. Anytime he's out of court, it's him, it's just from the.
So it was like a year or two after I stopped talking.
Who did you first shot?
First in Smith, and then in Dallas.
Born and raised in Oakland. Graduated from Kimball High School in 1967.
All right.
A long time ago.
Well, I was after you.
Yeah.
At JJ Pierce in 1997.
My son went, my older son went to church.
Brisa.
I know, we need that.
For what I do for you.
You're my younger son. Great.
Going on, it'll be going for a year.
We don't know, I know. It'll be gone in a year?
No, well,
6 months, right?
but we have,
We don't hit it back to back. Something like that.
so you won't have to do it for a year. It's a lot of cake.
I literally had a look back the other day for work, and it was just notice of settings, orders, and I was like, oh, this thing.
So I was like, well, maybe not.
Oh. Robert, I'm not sure how Robert is. Yeah, he's. I think he's not in his schools yet. Because we live on Cedar. And so he grew up right across the water. We never did it. For years, I've seen this kid riding in and out of sleighs, one of those stand-up jet skis, not the one that 15 years, 20 years later, that's good. I think he is.
Okay. I will find out.
Oh, really? I brought my bike. Look at you. To go in the shopping. So I thought it was
All right. Be seated. Thank you. All right. Yeah, test result back to
I'm waiting. She had a minute to me prior to the UA. She had to dismiss the
I could tell.
But I'm waiting. That's what she-
Okay.
Judge, I'm not gonna be last.
You're not? What if I took Miss Fallhaber right now?
Then I will be last.
Well,
Okay,
do you have please?
I did, Judge.
Yeah, I think I'm just waiting on a drug test result. Well, I thought, is
I
it
thought
done?
that was her. I might have to go there and find.
It's not. I can go ahead and continue on, Mr. Stevens. Oh, she does? Okay, come on up, Bill. She has other ones. I thought that was the last one.
Okay, cool. I have Mr. Mitchell, Your Honor.
Mitchum?
Mitchell.
Mitchell, Mr. Mitchell, come on up. Just two?
Yes, sir.
Okay.
Considered several cases.
Let me get organized here then. So he is. I will off the record real quick. So he's going to plea on 0108 and 0102.
Yes,
All
sir.
the other ones are being considered.
That is correct, Your Honor. Yes, sir.
And we're abandoning and enhancing. Does he have an enhancement paragraph in each one?
I believe so, Your Honor. Yes, sir. Yes, sir.
Which would have made these a second.
Correct.
Okay. All right, I'm ready to get started on the record. All right, these are cause number CR 21-0102 and 0108-173. Both styled the state of Texas versus Michael David Mitchell. And these, along with other cases, were set for pretrial today. However, a plea on each of those cases has been presented to the court, which would resolve all the cases on the docket. Is the state ready? And on behalf of Mr. Mitchell.
Ready, Your Honor.
Right, sir, is your name Michael David Mitchell?
Yes, sir, dude.
And are you the same person that was originally indicted by Henderson County Grand Jury in each of these cases, the 0108 being the third-degree felony offense of fraudulent use or possession of identifying information, and in this 0102 case, this third-degree felony offense of forgery of a financial instrument against the elderly?
Yes, sir, that's me.
Is the enhancement a prior conviction or the elderly?
Prior conviction.
Okay, I might have just asked you that. All right. And sir, if you can raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
That's where you can lower your hand. Mr. Mitchell, can you read and write the English language?
Yes, sir, I can.
Are you a U.S. citizen?
Yes, sir, I am.
If it turns out you're not, and you enter into these plea bargains with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir, I do.
Mr. Mitchell, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, I do.
Mr. Stevens, do you believe your client is competent?
Yes, sir.
And the court can find that he is competent. Mr. Mitchell, I know that you've already been arraigned on each of these cases. However, would you like the prosecutor to read the indictments against you out loud here in the courtroom?
No, sir.
You understand the charge?
Yes, I do.
Well, as indicted, both of those charges are third-degree felonies. A third-degree felony carries a punishment range of not less than 2 years and more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand the range of punishment
Yes, I do.
in the plea bargain?
Your Honor, in both cases, it's 10 years confinement to TDC with 223 days credit. Attorney's fees are being assessed on CR 21-102. You've got court costs in both causes. Also asking the court to consider and dismiss CR 21, 103, 104, 105, 106, 107, and 109, and these two sentences that are one after each other.
Is that your understanding of each of these plea bargains, Mr. Mitchell?
Yes, it is.
Is that your understanding, Mr. Stevens?
Yes, sir.
Mr. Mitchell, a few minutes ago, I asked if you could read and write the English language, and you told me you could. I'm going to show you a couple documents here in a minute once I finish signing all these. First, the agreed plea recommendations. Did you read and go over each one of those with Mr. Stevens?
Yes, I
And
did.
did you sign the front?
Yes, I
And
did.
did you read and go over the back with him?
Yes, I
And did
did.
you sign the back?
Yes, I did.
Do you have any questions about it?
No, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, there's one for each case, but I'm just showing you one. They say the same thing. Did you read and go over those with Mr. Stevens?
Yes, I did.
And did you sign the second
Yes,
page?
I did.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights in each of these cases, including the right to trial by jury. Do you want a jury trial in any of these cases?
No, sir.
Do you want to waive your right to a jury trial and enter into these plea bargains with the state?
Yes, I do.
Then I'll ask you, sir, how do you plead in cause number CR 21-0102-173 to that third degree felony offense of forgery of a financial instrument? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, I am.
And in cause number CR 21-0108-173 to that third degree felony offense of fraudulent use or possession of identifying information, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, I am.
I hear the evidence.
Judge, for both causes, as states 1, the offense report, and states 2 is not more in compliance.
No objections.
Admitted.
State rests in both causes.
Defense would rest and close in both causes, to your honor.
All right, then, Mr. Mitchell, in cause number CR 21-0102-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third degree felony offense. The court granted or grants the state's motion to abandon the enhancement paragraph, considers CR 21-0103, 04, and 05-173 and sentencing you. Sentences you to 10 years in the Texas Department of Criminal Justice with credit for 223 days and orders you to pay your attorney's fees and court costs. And this case will run concurrent with CR 21-0108-173. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third degree felony offense. The court grants the state's motion to abandon the enhancement paragraph, considers CR 21-0109, 07, and 06-173 and sentencing you, sentences you to 10 years in the Texas Department of Criminal Justice, credit for 223 days, and orders you to pay your court costs. And of course, this case will run concurrent with the 0102 case. We got a couple more things to go over, Mr. Mitchell. In each of these cases, there's a judgment. Did you have an opportunity to review those with Mr. Stevens?
Yes, I do.
Was your name, the charge, and the time credit correct in each one?
Yes, sir.
All right, sir, and now that you've been convicted of these felony offenses, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions, consult an attorney. You're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you, sir.
Thank you.
Need to see Mr. Halbert to your right.
Thank you, Judge. Might be excused.
Yes, sir. You took care of a bunch of cases these past 3 days, I'll tell you.
I know, trying to help you docket, Judge.
I appreciate it. We'll be here this afternoon too, if you want to take care of some more then.
You're welcome. I don't think I'm here this afternoon.
All right.
I have to. Hang over.
All right, let's see. Miss Green, you want to come on up? All right, this is cause number CR 21-0209-173, back on the record in the state of Texas versus Misty Green. Miss Green, I normally don't test people with your charge. However, based upon your demeanor, I ordered you to take a drug test and my suspicions
I was almost through,
were
so.
confirmed. And you have tested positive for methamphetamine and benzodiazepines. And so what I'm going to do is I'm going to place you on conditions of bond. There'll be no alcohol, no drugs not prescribed, and no illegal drugs, and that includes THC, no marijuana or THC. And I am going to have signed that. And so when you come back in August, you'll be subject to be tested again. If you test positive in August, you may not go back out that door. You may go out that one, because if I have to put you in jail to keep you clean for your safety and the safety of the community, I will. I don't want to, but I will. So if you need help, seek it. And I know Ms. Fallhaber could probably steer you in the right direction. And I think she could probably steer you in the right direction at that too. She has a podcast I watched one time. I watched that podcast or whatever it was called.
I don't know what you saw. I've done all sorts of stuff.
I watched something that actually showed me and I thought that's pretty good. That's good.
All right.
She can help you out.
But the interview, I think it was from the body.
Ah.
It don't matter, I know.
Well, it matters, but you don't want to tell me.
I'm like,
Tell
I
her.
No, you're right.
Sometimes less is more, Misty. You're good to go. I'll see you soon. All right.
Ooh, boy, this is a talker. Cut the leg off a horse.
Imagine what my day to day is like.
Oh, trust me. I hear my wife talking to him on the phone all the time. I'm like, why do you answer that at 8 o'clock at night? We're trying to watch TV.
What you probably saw was I do like CLEs on wellness for the state bar. And
Yeah, it was that one. I think I watched one. Yeah,
Okay, cool.
Yeah.
Thanks.
I'm involved. People don't realize it. but I'm involved. Who you got?
We've got a motion to reconsider on the bond hearing for Sabian Young.
All right, Mr. Young, come on up. This is CR 17-0812-392, the state of Texas versus Sabian Young, and that is set on a motion to reconsider the bond.
Yes,
And if you'll remind me what happened the last time,
Your Honor.
I would assume I didn't grant it because he's still here.
Well, it was, you did grant it because it was a motion to set bond because he's on deferred probation.
I got you.
And you had asked the prosecutor what all of his other charges were. And as Mr. Young recalled the testimony from, well, not testimony, but the recitation of those other cases, he believed there was an inaccuracy that we wanted to clear up. And so,
Are you going to call him for the limited purposes of this hearing? Or
yes.
do you just want to tell me what he?
Well, I can tell you, and then we can take it from there, but he is prepared if he needs to give more testimony.
Well, I mean, I don't know if Mr. Cox, because Mr. Cox may want to cross-examine him on whatever it is that he's going to tell me.
Why don't you just make a representation to the court?
Yes. Because,
That's fine with me.
All right.
thank you. So, Your Honor, this case involved several other people, and so,
Is this one of those Athens Snipers for Life gangs? That's
yes.
the most ridiculous title for a gang I've ever heard. Anyway, go ahead.
And so,
I wouldn't be proud of it.
and so you had asked Mr. Cox at the last hearing what Mr. Young's other charges were. And at one point, it was recited that he had a manufacturing and delivering case, which is actually one of the co-defendant's charges and not
Okay.
his. And so you had set this bond at 162,500, and his other bonds, I think, totaled 87,500. And so he was of the opinion, his belief was that you were going to set the bonds on the bond on this case to match the bonds in the other case, so that it would be 87,500 versus what wound up happening, which was 250,000 total. And so there was just some back and forth and some confusion about that. And I did reach out to Ms. Forbes and ask just for an unofficial recitation of it. And let me pull it out.
Would be official.
While she's doing that, well, go ahead, Shane.
I mean,
Well, I
do you
was just
have
gonna
a,
say-
well, before we get, do you agree with Ms. Fallhaber's statements? I mean,
My recollection is the court wanted to make his total bonds, both on the motion to proceed and the new offenses, same as his co-defendants, which was $250,000.
okay,
which is
that was,
why-
I recall.
Yes, which was why it was 168,500 or something like that. So I think it's just a math issue.
Yeah, and I do think that because things, when they happen in court, it goes fast. And so I think there was just some confusion that I did go over, because I didn't ask Ms. Forbes to type out a full transcript, but just to look at it and see what was actually said, which did not reflect with my client's memory, because he thought that it was supposed to be 87,500 plus 87,500 to match. And so if that was not the court's intention, then I mean, the court did what Mr. Cox said, but there was some testimony or something in here about Mr. Cox saying that there was a manufacturing and delivering case, but then in another place he says it's 2 possession cases. And the 2 possessions is correct, and my client does not have a manufacturing and delivery. So we just wanted to get clarity on all of that. And Mr. Young also did want to ask if it would be possible, if it would be reduced, that he would even be willing to do an ankle monitor.
Well, what is the, what are his current, you're looking at it right now, Kevin?
Oh, was it?
Oh, I thought that's what you were pulling up.
Oh,
Well, thanks for riding along. I mean, I do recall though, while he's looking that up, that it was my intent that his bonds match those of all the others.
Even though the charges aren't the same.
Well, I think that if there's not already, just from what they're telling me in all of these hearings, is that this is I mean, are you alleging that this is a criminal street gang and that there's conspiracy between all the co-defendants? So I would imagine if that's the case, it wouldn't surprise me if they're all going to be involved in a criminal conspiracy case. And so in fairness to all the actors, whether you're the lookout driver, the guardian angel, or the guy that's, and this is just an example, or the guy that actually robs the bank or shoots the security guard, everybody's on the hook under law of parties. So that's why I wanted them all the same.
That's my recollection.
And I'm just not talking about this in a vacuum, it's just because of all these cases that are before the court, is that he's alleged to be in this Athens Snipers for Life game.
And if you still want to speak, I can call you as a witness.
I have to swear in that he's
Yes.
going to.
Do you still do?
Yeah, I do want to know what the bonds are.
All right, so on CR 17-0812-392, they show a bond of 162,005.
Okay.
So the one you switch to the next case.
All right, so the one that's actually on the docket is 162.5.
Yes.
And then he has a CR 21-0531-392, possession of controlled substance, 1 gram, 4 grams.
And I would assume the 17 is the motion to proceed case because it's so old.
Yes.
And I mean, if this were a motion to revoke, he'd be sitting there on a no bond anyway.
Yes.
I mean, he wouldn't be entitled to a bond.
Kevin, is your Odyssey being really slow?
It's not moving.
It's 30,000.
Well, $30,000.
On the CR 21 is that 31392.
Okay,
And then there's a 50,000 on an unindicted BCS 4200 grams.
PCS 4,200.
And there's a 5.
Hold on, you're going way too fast for me. And so what is the PCS? The unindicted PCS, 50?
Mhm.
And is there another one?
There is a PCS 23. That's a 5,000.
That's a misdemeanor.
Yes, and then there's a possession of marijuana and it's 2,500. So altogether.
That's, yeah. That's what the court's intent was. I have no idea how I got those to match up.
You're just good at math.
No, I'm not. I used to be before I went to law school. And that's 2,500. Okay, all right, so we've got the bond straight. I think I understand at least what the state's allegations are. And even, I mean, I'll just tell you, even without any alleged membership in this ridiculously named gang, I mean, cool names are like the Cossacks and Hell's Angels and the Bloods and the Crips. Athens Snipers for life. I've known some real snipers. They probably wouldn't appreciate this gang hijacking their name. I'd love to have them meet. Anyway, even without this allegation, I mean, he's on probation for a second-degree felony, burglary of a habitation. And then while he's on there, on that probation, you've got, what was the 0531 case?
PCS 1 to 4.
PCS 1 to 4, 30,000. PCS 4 to 200, 50,000. PCS PG 3, 5,000. Marijuana, 2,500. I mean, I think the bonds are reasonable, but I'll certainly hear testimony.
I would call my client Sadie.
Okay. All right, sir, if you can raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Now, Mr. Young, don't talk about anything. I know she's not going to ask you, but if you talk about the offenses, that's outside of this, and then you'd be subject to cross-examination. So just limit it to just bond.
Yes. And thank you for clearing that up. I am calling him for the limited purpose
Yes,
of this
ma'am.
bond hearing. Mr. Young, did you ask me to file this motion to reconsider?
Yes, ma'am.
And are you asking this court to lower your bond?
Yes, ma'am.
And why is it that you believe that this court should lower the bond?
Cause I got a lot of things to take care of right here. Like, I'm my little boy down when he came to visit me. He came to visit me. I just fly let my kids down.
Okay. And is there anything else? Well, let me back up. Did you want to tell the judge that you would be willing to wear an ankle monitor?
Yes, ma'am.
Okay. Is there anything else that you want the judge to take into consideration when deciding whether or not to lower your bond?
My job, I DoorDash for them. So like, other than that, just nothing outrageous.
And you would abide by all of the court's conditions of bond if you were released?
Yeah, I come to court, take a drug test every week or whatever I gotta do.
Okay. I'll pass the witness.
Mr. Cox,
No questions.
anything else from the state? And the state's opposed?
Yes, sir.
And I'll tell you what, Mr. Young, you're a polite young man. You're always polite when you come in here, but an ankle monitor doesn't prohibit people from committing offenses, because it's not like it's going to keep you from doing it. And you have a history of committing new offenses even when you're on probation. And so the court respectfully denies the motion to reconsider, and bonds will remain where they're at. And again, that's outside of any alleged gang affiliation. Thank y'all.
That's all I have today. Can I be excused, Your Honor?
Yes, ma'am.
I'll see you soon.
Oh, you still got one more.
Yeah, I forgot.
Maybe we can see you from.
Yes, sir.
Thought it was all I had.
Mr. Smith.
Did I already call him?
No, he was here and
Why did he leave?
I have no idea.
The order to take a UA?
No, he hadn't even come in. All right, well, this is cause number, or these are cause numbers CR 21-0091 and 0092-173. Post style, the state of Texas versus Christopher Smith. Sir, Christopher Smith in the courtroom. I see no one, I hear no answer. Is there a Christopher Smith in the lobby?
No answer.
All right, he's not in the lobby. He was here a couple hours ago. The time is now 11:15. The docket was for 9. Mr. Smith was here, but his case wasn't called and he wasn't told he could leave, so the court will entertain a motion.
State moves for bond forfeiture.
Granted, capious will issue, he'll be held with no bond. All right, see you later.